All right. Good morning, everyone. Welcome to Collaborative Administrative and Judicial Review Opportunities. I'm Sally Bernstein, Forest Program Coordinator at Sustainable Northwest. This webinar is part of the Pacific Northwest Forest Collaboratives Workshop webinar series. We're joined by Susan Jane Brown of the Western Environmental Law Center, who will lead our presentation today. Before we begin, there are a couple of ground rules we just need to lay out. First is mute your microphone. Everyone will be muted for this entire webinar. As well as keep your video disabled. If anyone breaks these rules, I will dismiss you from this webinar. The chat box is enabled only to chat with host. Ask your questions as they arise, and I'll make sure that Susan Jane gets them throughout the presentation, but we'll also be hosting a Q&A at the end of her presentation. So stick with us and your questions should be answered. If not, we can follow up afterwards, and we're happy to help with anything that's lingering. So with that, I'm going to hand this over to Susan Jane Brown to lead us through her presentation. Welcome, Susan Jane.
Thanks, everybody. My name is Susan Jane Brown. I'm a staff attorney with the Western Environmental Law Center in Portland. And I also am a founding member of the Blue Mountains Forest Partners in John Day, Oregon. Let's see, hey Sally, I can't share my screen. So can you allow me to do that? And then we can go ahead and get going.
Does that work?
Yep, there we go. Perfect. So let me just give this a second. Okay. So thanks everyone for joining us today. This is the second in a series of webinars on a lot of process. My colleague Pam Hardy and I did a webinar for collaborative groups on the National Environmental Policy Act process. And as part of that, there were a lot of questions about the administrative and judicial review process. And so this webinar is a follow-up to that. So we're going to talk today about administrative review opportunities that the Forest Service provides for all members of the public that the collaboratives can also take advantage of, as well as the judicial review process as well, because I know there are a lot of questions about that. So my presentation is going to be in two parts, the first on administrative review and then the second part on judicial review. And I'll stop after we get through the first part to see if there are questions on administrative review. And then at the end, we can take questions about administrative review and judicial review. So just know that there will be a couple of opportunities for you to ask some questions in the chat box. So the first thing I want to talk about is a brief primer on a citizen's right to petition her government for redress. The First Amendment of the First Amendment to the United States Constitution prohibits Congress from abridging the right of the people to petition the government for a redress of grievances. And so to provide for a avenue for the public to petition the government for redress, Congress has enacted several laws that provide the statutory and regulatory authority for administrative and judicial review of decisions made by federal agencies. So in this case, we're going to be talking about the Forest Service. The Forest Service, in turn, has also enacted regulations in the Code of Federal Regulations, or the C.F.Rs, that guide how the public may seek administrative review of a decision made by the agency. And we're going to talk about some of those administrative procedures today. So the right to petition for redress, in general, seeking administrative review or challenging or objecting to or contesting a federal agency decision is required in order to do something called exhaust administrative remedies, which is a technical term, and we'll talk a little bit more about that. But you have to do that in order to exhaust your administrative remedies and to establish what's called standing, which is the capacity of an individual or an organization to seek judicial review of a final agency action. So you can see that all of these principles are sort of stacked on top of one another. So when we talk about administrative review of Forest Service decisions, I want to talk a little bit about how that process is set up and the requirements. The Forest Service now has what's called a pre-decisional objection process that it uses to conduct administrative review of project level agency decisions. So these are decisions like a timber sale or a grazing lease or a trail construction project. These are project level agency decisions. And these provisions for administrative review are found at 36 C.F.R. Part 218, or Code of Federal Regulations Part 218, which outline the steps an interested party must take in order to seek administrative review of a project level decision. It's important to note that the administrative review process occurs after the close of the environmental review process, and the administrative review process is actually governed by a law called the National Forest Management Act. So that is a separate law than the National Environmental Policy Act, which provides for environmental review. So environmental review is a NEPA process. Administrative review is a NIFMA, or National Forest Management Act process. So it's important to know that those two laws are separate and that they provide for two separate things. So NEPA is an environmental review process. NIFMA gives rise to administrative review. Administrative review occurs before the Forest Service makes a final decision, and it takes the form of an objection of the proposed decision. So we're going to talk a little bit about what an objection actually is, and that is a legal term. So when we talk about objections, we're not talking about the fact that perhaps you prefer tea versus coffee and you object to coffee. Objections are a term of art, a legal term of art that the Forest Service uses to talk about their administrative review process. So in order to have standing, in order to litigate a project, an individual must have commented on the project during the environmental review process. So during the NEPA process, you have to have commented on the project in order to have standing that gives rise to your ability to object. So there is a causal chain here, or a temporal chain of events that we're talking about. The objection also must be based on issues that have been previously raised before the agency during the NEPA process. So this idea here is that in order to object to a project, you have to have commented on the project prior to the objection process, and you need to have flagged that issue that you're objecting on in the NEPA process. And so this is basically the idea that you can't sandbag the agency. You need to raise issues before the agency before you seek administrative review of that issue. So this is just really a fair notice issue. We need to make sure that the Forest Service is aware of your concern prior to going through the administrative review process, which is just a matter of fairness. So in terms of what must be in an objection, the regulations specifically speak to what must be in an objection. And those things include the objector's name, address, telephone number, name of the proposed project, the specific issues objected to, as well as citations to previous comments where the issue was raised. So again, you need to be able to cite back to where you've raised this issue in the past prior to seeking administrative review of that issue. The regulation at 36 CFR 218.8, which is on the slide there, lays out the requirements of what must be in an objection, and I would encourage you to take a look at that for the complete list of things that must be in a valid objection. So interested parties. So as the Forest Service's pre-decisional objection process doesn't specifically provide an avenue for interested parties to participate in the administrative review process. And the reason why this matters to collaborative groups is that oftentimes collaborative groups are interested parties. In many ways, depending on your collaborative and the project, you may have worked with the Forest Service to develop the particular project at issue, and so you're an interested party. But the regulations don't specifically provide an avenue for interested parties to participate in the administrative review process. Interested parties are typically those that don't involve themselves in the NEPA process and therefore don't have standing to seek administrative review of a project. but the interested party may have an interest or a stake in the outcome of that project. So you can see, as a collaborative group, if you were involved in developing the project, for example, you may have a stake in the outcome of that project, so you're an interested party. So, of course, if a collaborative group does participate in the NEPA process by providing official or formal written comments to the Forest Service, then you don't really need to worry about being an interested party because you are an actual stakeholder and you have been involved in the NEPA process. So you wouldn't need to avail yourself of an interested party process. But collaborative groups and I should also mention that collaborative groups that do provide formal comments on a project don't need to have any sort of official status. So you don't need to be a 501c3 organization. You don't need to be a state organized organization under state law. All you have to be is a group of people that are interested in the project. So you don't have to have a formal tax-exempt status, for example. So let's talk a little bit more about interested parties and how they can avail themselves of the administrative review process. There's a lot of words on the screen, so I apologize for that, but this is a direct quote to the Forest Service's regulations involving interested parties. And this regulation clearly states that while objection resolution meetings, which are meetings that the Forest Service will call that gather together objectors to work through their objections and to attempt to resolve those objections. So during the objection resolution meeting, there is no formal public notice requirement. So no notice in the Federal Register, for example, is required. But these meetings are open to the public. So they are public meetings. And as meetings that are open to the public, the Forest Service does need to make them open to the public. But what's important to note about this particular regulation is that it doesn't define what participate means. And so the involvement of interested parties or even of objectors in an objection resolution meeting, what that participation looks like is really up to the Forest Service. So the Forest Service has complete discretion to decide how to structure an objection resolution meeting and how and in what way to involve interested parties. So for example, a reviewing officer can decide whether interested parties can speak at an objection resolution meeting, whether they can appear in person. So pre-COVID, objection resolution meetings were held in person and objectors were invited to that meeting. But whether or not interested parties could appear in person was up to the discretion of the reviewing officer. So the Forest Service can structure the involvement of interested parties. So whether you can speak, whether you can engage with other objectors, whether you can appear in person, all of those sorts of things are within the discretion of the reviewing officer. And that's pretty important to note. So it's also important to note that a reviewing officer doesn't have to be consistent in how they involve interested parties. So the reviewing officer may allow a collaborative group to participate as an interested party and speak and provide information during an objection resolution meeting for one project, but not in a different project. A different reviewing officer may have different protocols. So it really is a very discretionary and flexible process how a reviewing officer may involve interested parties, including collaborative groups, in the objection resolution process. So that's important to know. So another important point that I want to flag for folks is that even if a reviewing officer does permit a collaborative group to engage in an objection resolution meeting as an interested party, this participation does not confer standing on that group to later involve itself in legal proceedings should a project be challenged in court. So as an interested party, simply because a reviewing officer allows you to participate in an objection resolution meeting does not mean that that collaborative group can then challenge that project in court. So in order to challenge a project in court, you have to go through the NEPA process, provide formal comments, and then engage in the objection process as an objector, not as an interested party. So it's important to know that the role in which a collaborative group decides to engage with the agency, both in the NEPA process and in the administrative review process, really matters, and it sets up your rights for the future. So that's an important thing to keep in mind. It's also important to note that as collaboratively developed projects have become much more common, some collaborative groups have sought permission from the Forest Service to act as interested parties and to participate in the objection resolution process. And the way that most groups have done that is basically just to send a letter in writing to the reviewing officer and to seek permission to participate. And that's how all interested parties should seek to participate as interested parties in the objection resolution process, is just to send a letter to the reviewing officer and to make that request. Again, the reviewing officer can deny that request, and they can put parameters or restrictions on that engagement. So just know that that may look different depending on the project, the reviewing officer, and the interested party. So that's about interested parties. But let's talk about objections specifically. So if a collaborative group does decide to formally participate in the environmental analysis process, which is the NEPA process, by submitting comments on a collaboratively developed project, then that collaborative group would have standing to participate in the objection resolution process as an objector, provided it actually objects to the project. And this is kind of a little bit of a weird thing for collaborative groups. Typically, collaborative groups come together to reduce the types of disagreement around a project and have participated robustly in developing a project. So at the end of the day, when that project is complete and through the NEPA process, collaborative groups may not want to object because you support the project, and that makes a lot of sense. That's one of the goals of many collaboratives, is to overcome disagreement by working together. So it's weird to support a project on one hand and then object to it on the other hand. However, if a collaborative group wants to be a full party in the objection resolution process, then you do need to object to the project, which I understand is, again, a weird concept if you actually support the process and the project. But that is the administrative review procedures that the Forest Service has for project level decisions. So even if you like the project, if you really want to be engaged as a full party during the administrative review process, you do need to object to it. And we can talk a little bit more if there are questions about what that form of that objection might look like if you actually support the project. So it's important to know there. So let me take a pause there because we're going to move next into judicial review opportunities. So let's see, Sally, if there are any questions about the administrative review process before we move on to judicial review. Oh, you're on mute, Sally.
It doesn't look like there are any questions in the chat box right now, but if we want to take a minute, it looks like there are 2 people with raised hands, and others can write their questions in the chat box. Let me see who's raised their hand. Alex, I'm going to unmute you so you can ask your question.
Yeah, hi, can you hear me?
Yep.
Yeah, so a question about this objection review process, and maybe you're going to get to this later, but are there standards on how the responses have to come? I'm speaking from a real situation that we've been involved in with heavy objections to a particular Forest Service project in our area, and a lot of us wrote in very substantive comments. I mean, we're talking about, I think a local group put in a 73-page comment, substantive, right? And then many of us individually put in multi-page comments. I mean, there were like 400 objections to this project. And what was interesting, you know, and we were following the process you talked about, you know, we commented on the preliminary, the environmental, then came the objection period. We put all this stuff in as objectors. And then we got the results from the Forest Service. And basically, they didn't address the substance of our very detailed substantive
Mhm.
objection. They said, you put in like 5 pages about why in detail the project does not meet its objectives, or in fact, it's doing actions that are contradicting their objectives. You make a long article, you cite scientific articles, and they come back with things like, oh, the project does meet its objectives. It's like, see what I mean? Like they just make this statement, high-level statement of, no, it's okay, without actually getting into the substance of what we submitted. So the question is, what is the regulatory and legal framework on which we then would base, wait a minute, you didn't address the substance of my objection. You simply said, oh, you've stated that you've addressed my substance, but you actually haven't, if you
Right.
look at what you wrote and what I wrote, right?
Yep. Yeah, so good question. And that can be pretty frustrating. I would agree. I've been in that boat also. The Forest Service's regulations do allow the agency some flexibility in responding to comments. And this is going to get a little bit weedy here, so bear with me. For environmental assessments, the Forest Service actually doesn't have a binding obligation to respond to comments. Oftentimes the Forest Service does that because it is good public engagement and education procedure. So it's good practice to do that sort of thing. But strictly speaking, there's not a legal obligation for the Forest Service to respond to comments on an EA. On an EIS, there is an obligation to respond to comments, but how the agency does that is fairly flexible. So for example, if you have 400 objectors and 20 objectors raise an issue about grazing, then the Forest Service can group all of those objections on grazing and respond to them sort of in bulk and say, so we heard this on grazing, here's our response. So it doesn't necessarily have to be a point-by-point response, nor does it have to be an objector-by-objector response. So the agency can group their response by issue or by other means that make sense for the agency. Generally speaking, the Forest Service should respond to objections with some additional response. So rather than saying, we actually do think this project meets the purpose and needs, see pages 30 through 60 of the EA. I agree with you, that's not a very satisfying response, but it may be adequate in many cases. However, it is, when you get down to litigation, and if you decide that you really don't like this project, there are legal claims that you can bring, particularly for an EIS, that the agency didn't adequately respond to comments. I'll say from my experience as a legal practitioner for the past 20 years, those sorts of claims frequently are not not successful in court. So it's sort of a question of how much time you really want to spend complaining about the agency's response or lack thereof to your objection. I would agree it's frustrating, but there may be better legal angles than that particular one. But I'm totally with you. It can be really frustrating.
Well, let's ask the question again. The problem is not that they wrote a document that didn't address the issues we wrote. The problem is that the project doesn't address
Right.
the issues we wrote.
Right.
So when you talk about legal claim, I'm not so much focused on a legal claim that, oh my God, they didn't follow procedure because they didn't reply with a piece of paper, right?
Yeah.
I'm more interested in
Substance.
when I see that, how is that setting up for a legal
Yeah.
challenge that is effective, right?
Right.
Potentially on the substance of the issues that we raised and they didn't actually substantively respond to, right?
Yep. Yeah, and that would come out in litigation. So for example, if you raised an argument that the project doesn't comply with a forest plan requirement to retain a certain number of snags post-project, for example, then your legal argument would probably be that the Forest Service violated the National Forest Management Act in their forest plan, which requires projects to retain a certain number of snags. So if the project doesn't do that, then your legal argument is the project violated the forest plan and therefore the National Forest Management Act. So that's how you kind of reduce your objections to a substantive legal violation later once you get to litigation.
Thank you for your question. I think for the sake of time, we're going to move on. There is one more question from Dave.
Okay.
He's wondering if the objection needs to lay out legal arguments showing how a decision runs against a specific policy. How technical does the objection have to increase likelihood of success?
Yeah, so that's a good question. So the administrative review process is meant for normal people. It's meant for normal humans. It's meant for members of the public. And so the law will give you a lot of flexibility when it comes to raising objections, particularly of a legal nature, because the courts do not expect members of the public to know magic language to raise legal issues. What the administrative process does require is for you to raise an issue with sufficient specificity for the agency to know what you're talking about and to understand what legal obligations on their part it triggers. So for example, if you were to say, I really like woodpeckers and I'm very concerned about the viability of woodpeckers in this project, and I know that woodpeckers need snags for, to do their thing as woodpeckers. And I'm concerned that this project isn't retaining enough snags for woodpeckers. That kind of general concern about wildlife and what they need is sufficient to raise a legal issue and to preserve it. And that's a legal phrase called preserving an issue for judicial review down the line. If you were to raise an issue like that in your objection or your comments, that would be sufficient for the agency to know, okay, this person cares about snag retention, and we know as the Forest Service that our forest plan requires us to retain a certain number of snags for woodpeckers and other wildlife. So we know that we need to do that and to demonstrate that in our project. So there's a fair amount of leeway for the public to flag issues for the agency sufficiently so that the Forest Service can figure out what your real concern is and what legal obligation that triggers on their part. Part of the objection process is also that if the agency isn't clear about what your concern is, it's an opportunity for the Forest Service to clarify that with you. So for example, if you're concerned about woodpeckers, the Forest Service can say, are you concerned that we're not retaining enough snags for woodpeckers? Or are you concerned that we are introducing an invasive species that is going to outcompete native woodpeckers? And so the objection resolution process is an opportunity for the Forest Service to clarify with an objector about what the real concern is. And the idea there is that if we can clarify things and resolve those areas where there is some question about what the objector's concern is, then we can work that out prior to making a final decision. So I hope that answers your question. Oh, you're on mute again, Sally.
There we go. There's something that's not muting today. Why don't we move on and we'll answer remaining questions at the end.
Okay, great, cool. All right, so that's administrative review, and we can answer or we can take more questions at the end. But let's talk a little bit about judicial review. So once the Forest Service makes a final decision to implement a project, the decision is what's called ripe for judicial review. And a party challenging a decision in court must have standing, which we talked a little bit about. And in this case, standing means that you've participated in the NEPA process and you've participated in the administrative review process. So you've done both of those things. That means that you will have standing to bring a challenge in federal court. In the typical case in which a collaborative group has not provided formal comments in the NEPA process and has not participated as an objector, the collaborative group would not have standing to seek judicial review of a project. So that's important to know. And that's true for any member of the public or any other organization. In order to have standing, you have to comment in the NEPA process and you have to go through the administrative review process first. So there's no getting around that. So if a party does want to seek judicial review, so let me hang on just a second, let me back up. So if a party does seek judicial review of a Forest Service decision, so an organization or an individual who went through the NEPA process, went through the administrative review process, and does not like the project and decides to file suit in federal court challenging that decision, a collaborative group or other interested party has basically two options to participate in that judicial proceeding. The first type of avenue that a collaborative group, for example, would have is called intervention. And then the second avenue is appearance as an Amicus Curiae. And we're going to talk about both of those here next. So in litigation, there are typically two parties, the plaintiff and the defendant. The plaintiff is the party who has standing to challenge the project in federal court, and a defendant is the party who supports the action. So in this case, it's the Forest Service, because the Forest Service made the final decision to implement a site-specific project that a plaintiff doesn't like. So in this case, the plaintiff can be a private individual or an organization, and as I said, the defendant is the Forest Service. The plaintiff and the defendant are full parties to the litigation and can file motions, briefs, and participate in oral argument. So those are our two types of main parties that we have in litigation. However, there is a third type of party, and the most common way for a party to engage in litigation who is either not the defendant or the plaintiff is as an intervener. And a party is an intervener who has a demonstrable interest in the subject matter of the litigation, but does not necessarily have standing to bring or defend a lawsuit. So interveners are different than plaintiffs or defendants. There are two ways that a party can intervene in ongoing federal litigation, and that is as of right or permissively. I'm going to talk about each one of those. So intervention as of right is granted by a court when a party can demonstrate that it has, and this is a technical sentence, so bear with me, but a party can demonstrate that it has an interest relating to the property or transaction, which is the subject of the action, and the applicant is so situated that the disposition may, as a practical matter, impair or impede the applicant's ability to protect that interest unless the applicant's interest is adequately represented by existing parties. So basically, if you're moving to intervene as of right, you are able to demonstrate that you have an interest in the litigation that as a practical matter will affect your interest in the matter that is the subject of the litigation. So essentially, a party has to demonstrate that they have the right to be part of this litigation, to intervene as of right. A party who cannot meet those requirements to intervene as of right can also seek to intervene through permissive intervention. And permissive intervention is appropriate when a party can demonstrate that its interest shares a question of law or fact in common with the underlying action, and if the intervention will not unduly delay or prejudice the rights of the original parties. So permissive intervention is a much more lenient standard of intervention, and it relies on what are called equitable concepts. So the court may grant permissive intervention when the principles of fairness indicate that a party should be part of the litigation, even if they do not have the right to participate in the litigation. So you can see that it is permissive. It's not that you have a right to be there, but that you should be. And those are two different things in the eyes of the law. So the judge, in her discretion, will look at an application for intervention and in her discretion decide whether a party should be granted permissive intervention. And there is no test here for what qualifies for permissive intervention. It's really up to the judge, and it's really highly fact-specific as to whether permissive intervention is appropriate. On the other hand, intervention as of right is a fairly strict requirement, and there's a lot of case law interpreting whether or not intervention as of right is appropriate. So two different types of intervention, two different standards of intervention. One, the permissive intervention is a much lower standard of intervention than the as of right. So probably if a collaborative group is interested in intervening in litigation, permissive intervention is probably going to be the way that a collaborative group is granted admission. Interveners do participate as full parties in litigation, which means that interveners can file motions and briefs and participate in oral argument before the court. Importantly, courts can and do tailor intervention, and they can structure the involvement of intervening parties. And what this often looks like is page limits on briefs and time limits on oral argument. But otherwise, interveners file briefs and motions and appear in court just like plaintiffs and defendants do. So that's important to note. Because collaborative groups typically, although not always, generally support a collaborative project that is now in court, typically a collaborative group then would permissively intervene on behalf of the Forest Service. So that means that you step into the shoes of the Forest Service. You would be characterized as a defendant intervener. So you do step in, as I said, step into the shoes of the Forest Service. When you do that, and when you file motions and briefs to support a project, the perspective that you would be offering in those motions and briefs would be the perspectives of the collaborative group. So, for example, you may want to talk about the collaborative process that led to the development of the project. You may talk about the important ecological or socioeconomic considerations that gave rise to either the collaborative process or the project itself. So you're going to want to really focus on why you're here. What are your concerns with the litigation and that sort of thing. So that's the type of approach or perspective that you would share as a collaborative group intervening on behalf of the Forest Service. Often, although not always, interveners also will coordinate with the party on whose behalf they are intervening. So in this case, the Forest Service. Oftentimes you will have legal counsel for interveners and the party on whose behalf they're intervening, in this case, the defendant Forest Service. So your attorneys would coordinate. They would coordinate around issues that may be discussed in the briefs or particular positions you might take on other motions, that sort of thing. That sometimes happens, but not always. So it's just important to note that sometimes there's coordination amongst intervening parties and the parties they defend in the litigation, but not always. So just something to note there. So some considerations that parties may want to consider if you are thinking about intervening. And these are considerations that you should always think about when you're thinking about engaging in the legal process. And they basically come down to time and money. The primary cost associated with intervention is paying for an attorney. Most private attorneys charge their clients based on an hourly rate that reflects the attorney's specialization, years of practice, and other considerations. Other attorneys will charge a flat fee or flat rate for representation. The rates do differ dramatically depending on where you are. So if you are in Seattle, the cost of an attorney is going to be greater than if you are an attorney in Wenatchee, for example. So depending on where your attorney is, they will cost different amounts of money. Also, depending on how much experience and expertise they have. On the other hand, pro bono attorneys will typically undertake representation of a party at a much reduced or even a free rate. So for example, the Western Environmental Law Center, my organization, represents our clients pro bono, which means we do not charge them for our attorney time. We don't charge them for representation. However, when attorneys represent interveners, particularly in natural resources litigation like what we're talking about today, attorneys are generally not eligible for attorney's fees under fee shifting statutes like the Equal Access to Justice Act. And so as an intervener, your attorney is probably going to want you to pay them because they don't have the option of recouping fees if they are successful in the litigation. So you really do need to be prepared to pay your attorney out of pocket if you are seeking to intervene in litigation. Other costs associated with intervention include copying and printing costs, postage, legal database research, travel, telephone use, that sort of thing. If you choose to hire an expert, you would also need to pay your expert their costs as well. The other consideration is time. So the time commitment on behalf of interveners is pretty much what you make it. Some interveners want to be very engaged in the litigation. They want to talk to their attorney about claims and how to respond and facts and that sort of thing. Other interveners don't want to be as actively engaged. So it really depends on your collaborative group and how engaged you want to be in the legal process. Given that collaboratives are by nature cooperative entities, you may want to spend a lot of time with your attorney, talking to them about the process and about the project and why the group came together or why you're working on a particular landscape. So you really need to think about how much time it's going to take on your part, as well as your attorney's part, to engage in the intervention process. And keep in mind, because you are paying your attorney probably an hourly rate, you may want to consider how many hours you take of your attorney's time talking to them about the background of a project, for example. So it's just something to keep in mind to balance how much time and money you're investing in the litigation process. So important considerations for anyone engaging in the judicial process. So we've talked about intervention so far, but I'm going to talk about another avenue for collaborative groups to participate in the judicial review process, and that's as an amicus curiae, which is a Latin phrase. It's probably the most mispronounced phrase in litigation, and the law does use a lot of Latin phrases, so we use this one quite a bit. And an amicus curiae is what it's Latin for friend of the court. And amicus were traditionally non-parties to litigation, so parties that don't have a stake in the litigation, but their chief function historically was to prevent an uninformed legal or factual error from prejudicing the litigation. So amicus, or amici, which is plural for amicus, amici were there basically to make sure that the court had in front of it particular information that the plaintiff or defendant would not ordinarily provide the court. So that was their traditional role. Today, however, amici typically are parties who do have a strong interest in the outcome of the litigation, and collaborative groups fit pretty well within this role. But there are a couple things you need to know about participating as an amicus. First of all, they most traditionally appear at the higher levels of the judicial system. So not in the district court, but much more frequently at the courts of appeals, and really where you see them is in the Supreme Court. So by the time a case gets to the Supreme Court, it's probably generated a lot of interest from a lot of people that probably didn't even know that the lawsuit was going on when it first started. But by the time it gets to the Supreme Court, it may have engendered a lot more attention. And so you see a lot more amicus filings at the Supreme Court, but they do appear at the courts of appeals, and these days are appearing more regularly in the district courts as well. Another thing that you need to know is that a party who wants to appear as an amicus must seek the written permission from the existing parties to the litigation. So that means that you've got to go to the plaintiffs and the defendants, and you need to ask them for their permission to appear as an amicus. If those parties do not give you that permission, then you can move the court to appear as an amicus, and that would require a motion and a memorandum in support of that motion. But the court doesn't have to grant appearance as an amicus, and that decision is really vested within the judge's discretion. So whether or not the judge is going to let you appear is really up to the judge. Typically, amicus only file one brief in the litigation, whereas the other parties may file several briefs or more. An amicus is really only going to file one brief, and they're going to file that at the beginning of the litigation, setting out their position. And I'll talk a little bit more about what an amicus might have to say. But courts do have the discretion to determine whether amici may participate and in what way. For example, amici may not be given the opportunity to appear at oral argument. So that is a consideration as well. Courts have also been very clear, and I expect this trend to continue, that an additional party to the litigation, like an amicus, means more paperwork for the judge. And courts have been pretty clear that participation as an amicus should be a relatively rare occurrence. So I would not recommend that collaborative groups go out and start filing amicus briefs. But if you really do feel like you should be part of the litigation, it is an opportunity for a collaborative group. But just know that particularly in the district courts, judges are going to be fairly skeptical of letting you participate as an amicus, just because they frankly don't want additional pages to read. So if you, and that counsels for really carefully tailoring your participation as an amicus. So what would perhaps get the attention of the judge? So the reasons why you might want to participate as an amicus is to put forward policy issues that the parties would not otherwise address, to endorse a particular position, to provide a historical perspective for how we got here and why we're here now, to provide technical assistance, and this is a historical role of amicus, is to provide technical information. So for example, if the project involves a new research procedure or survey method, and your collaborative group was involved in developing that methodology, you may want to let the court know, hey, this is our methodology and this is how we got there. You can also use the amicus process to apply political pressure, to provide socioeconomic information, or importantly, to explain the real world implications of the litigation. So what happens if the court decides one way or the other for the plaintiff or the defendant? This is what it's going to mean in the real world on the ground. So that's an important role of an amicus. Amicus briefs should also be short and to the point, and duplication of arguments that either the plaintiffs or defendants are going to be making is highly disfavored. So don't do it. You really should stick to providing some of those perspectives that I just mentioned in terms of, historical perspective, technical expertise, real world impact, that sort of thing. So you really should focus on those things and not the legal arguments that the other parties are going to be making. Some considerations about whether or not you want to participate as an amicus are the same as whether you want to participate as an intervener. So time and money. So those things are the same considerations for whether or not you participate as an amicus. We've had some questions that came up during the first webinar on NEPA about injunctions. And so I wanted to cover this just a little bit. Often in litigation, a plaintiff will seek what's called an injunction, which is an equitable remedy that a court can order that either orders someone to do something or to refrain from doing something. So in this case, a plaintiff may seek an injunction to stop implementation of a project. If a party thinks that the emergency relief will last for a short period of time, they will file a motion for a temporary restraining order, or a TRO. If that injunction needs to last for longer, then they will move for a preliminary injunction, which is an injunction that lasts longer than a temporary restraining order. As an equitable remedy, the court has the discretion as to whether or not to grant the motion for an injunction. And the court is going to look at 4 factors when determining whether or not to grant an injunction. 1, whether the party is likely to succeed on the merits, i.e. that the plaintiff can prove a violation of law. 2, whether the party is likely to suffer irreparable harm in the absence of preliminary relief. 3, whether the balance of equities tip in their favor. And 4, whether the injunction is in the public interest. And that is a 4-part test that's been set by the Supreme Court. There's also substantial case law regarding each one of those factors. So a court is going to look at that case law and the particular facts of a particular case in evaluating whether to grant the motion for an injunction. So this is a highly fact-specific inquiry that the court's going to go through. If you are a party to the litigation as an intervener, you will be able to take part in the briefing around whether an injunction should be granted or not. Another important point I want to make about injunctions is that only if a motion for an injunction is granted by the court may the implementation of a project be halted. So simply the filing of a lawsuit or the filing of a motion for an injunction does not mean that project implementation stops. Instead, a judge must issue an order stopping project implementation. Also, a court may find that a party has or is likely to prevail on the merits, so the plaintiff is likely to demonstrate that a violation of law has occurred, but still not issue an injunction. So what that means is that by balancing the equities, so the court will look at, okay, I think that there's a legal violation here, but I'm not sure because this is preliminary. But on the other side of the scale, we've got all of these equitable considerations. So irreparable harm, whether the injunction is in the public interest, and whether the balance of equities tip in favor of the injunction. So the court is going to go through this balancing process and determine whether or not an injunction should issue. And only if the equities favor an injunction will a court order the project to stop. So I think that's an important piece of information to know. So a couple things that I just want to touch on before we finish up here is settlement. It's important to note that plaintiffs and defendants can settle litigation that the plaintiff has brought, and interveners sometimes, but not always, are part of a settlement agreement. Interveners can object to a settlement agreement, but the court will determine whether or not the interveners can participate in that objection. And it's also important to know that amicus are not involved in settlement negotiations, so that is a difference there. I see I got a question about the 4 factors for an injunction, and we can put these up and make these slides available at the end of the presentation. But the 4 factors are the likelihood of success on the merits, 2, whether the party moving for the injunction is likely to suffer irreparable harm if the injunction is not granted, 3, the balance of equities tip in the favor of the injunction, and 4, whether the injunction is in the public interest. So those are the 4 factors that a court will look at as to whether or not an injunction should issue. So some other considerations to keep in mind when you're seeking legal advice. Most people hope to never need a lawyer and think of the legal process as something that is super scary and very difficult. It really doesn't need to be that scary or difficult, but it is something that you should treat with the type of attention that you would anytime you seek professional counsel, whether that's a doctor or a plumber or anything like that, which is that it pays to do your homework. So many lawyers have specialties like practicing environmental, natural resources, or land use laws. And in the event that your collaborative group doesn't have one of these experts on speed dial, your state bar association can help put you in touch with someone who has this expertise and is willing to work with you in these issues should you decide to go into the legal or judicial review procedures. So a couple things that you're going to want to think about. Again, cost. Pro bono and reduced cost attorneys are not the norm, so more than likely you are going to have to pay your attorney if you decide to engage in the legal process. Expertise is also something to keep in mind. Experience with federal environmental law is really useful in litigation of the type that we've been talking about today, but it's not necessary. And good lawyers are good lawyers regardless of whether or not they have expertise in the federal environmental laws that we typically work with. So familiarity with the issues is important and a consideration, but it is not the end all be all. The other thing to consider is scope of representation. So is your attorney willing to represent you just in the district court, or are they willing to represent you on appeal? Questions like that are things that you should definitely talk about with your attorney prior to engaging with them. After you have those conversations with a prospective attorney, they will provide you with an attorney-client agreement, which is a written document that spells out their obligations as well as your obligations. So this is a contractual relationship at the end of the day. The other thing that's particularly important, I think, for collaborative groups is the personality of your attorney. As collaboratives know, it's all about relationships, and whether you like and can get along with your attorney is an important consideration. And so, you know, someone may be an excellent attorney, but a really impossible person to get along with. And whether you can work with your attorney is important, because you may be spending quite a bit of time with that person, and you are also going to be paying them for their representation. So it makes sense that you're going to want to be able to get along with your potential attorney. So some things to think about when you're seeking legal advice. As I mentioned, not all collaborative groups have someone with legal expertise on speed dial. So if you are one of those groups that doesn't have that expertise in-house, I would recommend that you reach out to your state bar association, and every state has one. There are some emblems here, logos on the screen for each of the states in which collaborative groups are robustly working these days. And so you can reach out to your state bar and ask them for recommended attorneys who either have the expertise that you're looking for or are willing to work with you pro bono or at a reduced rate. So definitely feel free to lean on your state bar associations. That's what they are there for. They're there to help entities like collaborative groups get the best representation that they can. So I will stop there. That is all that I have. And I think I will turn it back to Sally for other questions and discussion.
Sally, you're on mute.
There we go.
My mute is not working today. Can you hear me now?
Yep.
Okay. We're going to take question and answer now. If you could use the chat box to ask your questions, I will read them out to Susan Jane. So we'll take a moment so everyone can type away. We did have one earlier from Dave, I think as a follow-up to his earlier question, and we can start with that. Do any objections get resolved, or should objections be considered a step toward getting the issue in front of a judge?
That is an excellent question. Technically, the objection resolution process is what it says it is. It is an attempt to resolve objections. And so, but it does depend on the decision maker. It depends on the Forest Service and how they want to structure those resolution meetings. Some line officers treat those meetings as simply an opportunity to share views, as opposed to trying to resolve disputes. So it really depends on the line officer and how they want to structure that objection resolution meeting. So in some ways, sometimes it can be a great way to resolve objections and concerns. Otherwise, in other situations, it is a necessary prerequisite prior to filing suit. So it's both. It really just depends on the project and the line officer and how the Forest Service really wants to engage with the public during that process.
We also had one earlier from Anthony. What would you suggest to see more consistency from the Forest Service?
I would, presumably that's about the objection resolution process. You know, it's really difficult, and I can empathize with the Forest Service. And the regulations provide the agency with flexibility to really structure engagement in the way that makes the most sense. But I think, as we've heard from some stakeholders, it can be really frustrating as a member of the public or a collaborative group or an organization when you don't feel like your concerns have really been heard and that there's a legitimate desire to work through disputes in the objection resolution process. The Forest Service did go to a pre-decisional administrative objection process from a post-decisional appeals process probably about 6 or 7 years ago. And the stated intention of that shift of when administrative review occurs was to help resolve disputes prior to making a final decision. I'm not sure that that has borne out in fact. But I appreciate the sentiment, and it would be great if we could actually resolve disputes prior to the agency issuing a final decision. But that's not always possible. And I think it's also important for the public to realize, and this is perhaps where the Forest Service could do a much better job, is that the public doesn't always understand where the Forest Service's decision space is. So for example, if the Forest Service has no decision but to issue a permit, for example, then the Forest Service should tell the public that we have to issue this permit, you guys. And so we can condition that permit with some environmental sideboards, for example, but we're going to have to issue this permit. And so that's important for the public to know, that the permit is going to issue, but where they can be influential is where those environmental sideboards are, for example. So I think it would be really helpful for the Forest Service to do a better job of explaining where their decision space is and where the agency is willing to make concessions and where it is not. Otherwise, we're all sitting here tilting at windmills that we're never going to be successful at changing. So I think being really clear about expectations and where the agency can and cannot change its decision would be particularly helpful.
People another moment to type. I know Trent has a question, so.
Great.
While he's typing, could you maybe give an example of how you've worked with a collaborative to work through an objections and resolution process?
Sure. So I work with the Blue Mountains Forest Partners, and we've been working on that forest together with the Forest Service since about 2003. And many of our projects that we work with the Forest Service to develop are objected to by various members of the public and organizations. And I will be candid and say that the process has not been 100% successful all the time with the collaborative's engagement with the Forest Service, because we have different district rangers and forest supervisors that want to engage us in that process in different ways. And so we have tried to work with the Forest Service to make sure that they fully understand where the collaborative is on the project elements that we've helped to design, and ensures that the Forest Service understands that it's important to the collaborative group that, for example, we actually do the aspen restoration work that the EA has talked about. And so we try to basically work with the agency leading up to the objection resolution process. We typically have not participated in the objection resolution process, although that may be changing in the future. And so it really just depends on the collaborative group, the line officer, and the project as you might want to structure your engagement.
Great. Tegan's asking, how would the process be different in challenging the Forest Service regulations versus a project? Is there any intent for environmental organizations to challenge the new Forest Service CEQ NEPA regulations?
Good questions. Yes, I'll start with the second question first. Yes, the conservation community will be challenging the CEQ final rule whenever that is released, and we expect that to come out next week. So there will be several lawsuits that will be filed against that final rule. I would guess that the same is going to be true for the Forest Service's NEPA regulations, which they are also in the process of finalizing. And I'd be happy to take more questions about those two challenges. It is a different process than a project level administrative review and judicial review situation that we've been talking about today. And I am not I am not aware of collaborative groups that have submitted comments on the CEQ rulemaking, for example. I do know that collaborative groups have submitted comments on the Forest Service's NEPA rulemaking. And there is no administrative review process for rulemaking. So when the federal government and federal agencies go through rulemaking, that is an entirely separate process. And it is not always, although it should be in many cases, like these two rules, it should be a NEPA process, but it is not. So it is an Administrative Procedure Act process. And collaborative groups or other organizations, other individuals who are dissatisfied with that final rule simply go to court and challenge those rules directly. So there is no administrative review process associated with federal rulemaking. So it is a little bit different than project level decision-making that we've talked about today.
We have one from Trent. If a collaborative is unhappy with a project and really would like a seat at the table with the forest supervisor to discuss the problems with content and with process, is there a way the collaborative should tee that up to be transparent and move in the spirit of collaboration?
Yeah, I think that's a good point that Trent raises. And one of the things that collaborative groups try to hold ourselves to is being open, transparent, and inclusive. That doesn't always work out so great, but we strive for those things. And the transparency piece is really important. And so I think it's important for collaborative groups as the project development process is going on and then goes into the NEPA process and then goes into the administrative review process, that collaborative groups are really transparent with their Forest Service partners about their interest. And so and how that interest may change over time. So for example, if your collaborative is working arm in arm with the Forest Service to develop a project, and then something happens and that project development starts to change and the elements of the project start to change to the point where the collaborative group is no longer comfortable with what the Forest Service is proposing, then the collaborative group should write that down and send a letter to the Forest Service and make sure that there is a clear understanding of where the collaborative group is, what those concerns are, and what the Forest Service can do to change the trajectory of the situation. It is up to the Forest Service to make a decision as to whether or not they want to engage with collaborative groups or to change the project in a way that is suitable to collaborative groups. The Forest Service is the decider here. And collaborative groups, just like other members of the public, can only help and try to influence the process. They are not the deciders. And so if your interest is one that you have concerns as a collaborative group about the way that a project is being developed, you should write it down and tell your Forest Service partners and continue to have a constructive engagement moving forward. And hopefully our Forest Service partners will reciprocate.
Another one from Dave. Do you have an opinion about whether collaborative objections are treated better or worse by the Forest Service than objections from collaborative members or individuals?
What was the first part of that question again?
Do you have an opinion about whether collaborative objections are treated better or worse by the Forest Service than objectives from collaborative members or individuals?
Yeah, I mean, I think the thing is that collaborative groups typically don't object. And so those, there isn't a lot of occasion for a forest supervisor or decision maker to treat collaborative objections different than other organizational or individual objections. But I do think that it sends a message when a collaborative group does have substantive objections to a project that the Forest Service is developing, particularly if the Forest Service is describing it as a collaborative project. There's been a lot of discussion in the press and in the courts about what is collaboration, how do you define it, what is it, what isn't it, and those discussions are ongoing. But I think that if you want to, if your collaborative group has concerns, you should engage in the NEPA process, and you should engage in the objection process, and you should, if you didn't engage in the NEPA process, you should ask to be included as an interested party, because you are an interested party and you do have a voice and you do have an interest in the outcome of the project. So I would certainly encourage you to object if you think you need to. And sometimes, frankly, that's the only way to get the Forest Service's attention, is to object, because it does set you into a regulatory process that's prescribed by law. So it does get the agency's attention, and sometimes that's necessary.
Here's another one from Trent. What happens when our Forest Service partners introduce new content between the draft EA and final EA, and how does that impact standing?
Yeah, so this is a little bit of a tricky issue, and it does happen where the environmental analysis process, the NEPA process, either goes on for a long period of time or doesn't, and there's new information that comes up in between the time that the draft EA or EIS comes out and the agency issues a proposed decision on that project, triggering the objection process. And it may be that the project is going along fine and you're happy with it, and then all of a sudden there's a proposed decision that is very different than what you thought it was going to be. And at that point, I would recommend that you object, that you send a letter to the Forest Service and you say, hey, look, I thought this project was something I could agree to, but things have changed and now I have a lot of concerns. And so here are my concerns. It's never a good idea to hide the ball. So if you have concerns, you should always write those down and always provide those to the Forest Service. And I would recommend that that's what you do. It may be that the Forest Service doesn't allow you to participate as an objector because you didn't participate in the NEPA process. But I think that if your concerns remain after the objection process and you're really at the point where you think you might want to litigate, then you should bring your complaint in federal court, and your attorney will help you work through some of those administrative exhaustion questions, because there is case law around situations when you don't have to exhaust your administrative remedies. That's a fairly narrow set of circumstances when you don't have to exhaust your administrative remedies, but there are exceptions and they are out there. And one of those exceptions is when there's new information that appears at the end of the process that the public didn't have an opportunity to comment on earlier. So there are exceptions. It gets a little weedy, but attorneys can and others with legal expertise can help you with that.
What about when the Forest Service changes from an EA to a CE or EIS partway through the NEPA process? What does that do to standing and legal options?
Yeah, same kind of deal. Sometimes the Forest Service will think that they're going to do an EA and then they're like, maybe we can squish it into a CE instead. And CEs have a different requirement for public engagement, and categorical exclusions are not subject to administrative review. So that definitely changes your opportunities to seek administrative review prior to litigation. If your project goes from an EA to a CE and you're not happy with the CE or the project, then really your only option is to file suit in federal court. So while there is an increasing use by the Forest Service of categorical exclusions these days, I'm not sure that in the long run is actually going to help expedite project implementation, because the only avenue that a concerned member of the public is going to have is to file suit in federal court. So in that way, you can see why the administrative process is a good one, because hopefully it helps eliminate or address concerns prior to the need to file suit in court. But changing the level of NEPA documentation can alter that kind of inquiry.
We have another question from Fran here. Can an EA be overruled by a note in the file?
No. I'm not sure what process you might be referring to, but that's not a thing. It's not a thing. When the Forest Service prepares an EA or an EIS, they must issue a decision on that document, and a categorical exclusion for that matter. And there are decision documents associated with each level of NEPA analysis. And that final decision, the agency has to issue a final decision before it implements a project. And so a note to the file isn't one of those three options. So I'm not sure the situation or the circumstance that you might be referring to, but not knowing more, I would say no, that's not really a thing.
All right, so let's move on to another question here. Can collaboratives or stakeholders object and litigate on draft documents? Some Forest Service ID teams have been reluctant to share details out of fear of it being used in court.
Mm-hmm. Yeah, I am sympathetic with that, I can understand why that would be a concern. The answer is no. When an entity objects or litigates, you're objecting to the draft decision, you're litigating the final decision. And while the Forest Service does engage in an iterative decision-making process, which means basically that, there's some draft information or a draft decision, and then the agency develops more information, it goes out for public comment, does some environmental review, and then changes its proposed action or its proposed environmental analysis based on those things. It is an iterative process. And so I think that, and when this comes up in litigation, I'll say that the Department of Justice is very good at explaining to a judge that, Your Honor, this was a draft specialist report. And we took public comment, and then we did some additional analysis, and then the final EIS has our updated current environmental analysis. So that draft report, Your Honor, is just a draft report. Our final analysis is where we rest our final decision. So our final decision is based on that final analysis in the final EIS, for example. But I can also appreciate that anytime a decision maker is exposing their decision-making process to the public, that's kind of a little, that's a little scary, and I can appreciate that. I guess what I would say to my Forest Service partners is, we're all making iterative decisions. And as long as you're clear that you are learning, that draft documents are just draft. And I believe that sunshine is a good disinfectant. And the more transparent the Forest Service is with the public, the better able the public is to understand the Forest Service's decision. So I always encourage my Forest Service partners to be very transparent and to put lots of things in the record on your way to making a final decision, because it does help explain how you got from A to B to C. And if you go from A to C with no B in the middle, that's a lot harder for a judge to understand. So I believe that iterative process and keeping that information in the record and available to the public is a good thing. But I'm aware that there's a difference of opinion on that.
What options do collaboratives have for projects that are implemented differently than the EA/EIS? Does implementation monitoring also have legal options?
Yeah, this is a struggle that I think all of us really face on a pretty regular basis, which is the EA says one thing and the decision says one thing, but then you go out in the field and different things are happening. And that's a really sticky wicket, I'll be clear. You can certainly go to court and say, Your Honor, the EA and the decision notice say this, and what we're seeing out on the ground is something completely different. And that is something that is a meritorious concern that may persuade a judge that the Forest Service is not implementing the project in the way that they said they would, which is to say that the decision notice and finding of no significant impact, if you're talking about an EA, or a record of decision, if you're talking about an EIS, those are binding decisions. Those are legal decisions that the agency must comply with. And so if in implementation, the agency is not complying with those obligations, that can give rise to a cause of action in federal court. And so implementation monitoring is important. It's also important for adaptive management. So if we're out there implementing projects, we should be learning whether or not those projects, even if they are implemented according to the EA, at the end of the day, are we getting the results we thought we were going to get from this project? And so implementation monitoring is really important because you can plug that information back into the adaptive management cycle and hopefully learn. So the next project we do, we have the benefit of how this last project did, and we can make changes if necessary.
A question from Marilyn. Is it harmful to the health of the collaborative if an individual objects on their own?
That's a really great question. And I would just go back to the transparency point. Collaborative groups, by definition, are collections of different people and different organizations and different interests. And as long as those individual members and organizations and interests are transparent, from the start about what their plan is. I don't think that individuals that then object or litigate harm the health of the collaborative, provided that they have been transparent and clear with what's going to happen. So most of us who participate in collaborative groups are familiar with sort of our organizational and operating principles and how we make decisions. And one of those things is we need to know how everybody's going to react to a decision that the collaborative makes or that the Forest Service makes on a collaborative project. So if a decision, if a project decision comes out that's a collaborative project and it makes some members of the collaborative uncomfortable, then it's incumbent upon those members to be like, I'm uncomfortable with this, and here is what I'm going to do. I'm going to issue a press release. I'm going to object. I'm going to litigate, or I'm just really uncomfortable, and next time I don't want to see this in a project, so I'm not going to do any of those things. So I think it's really important for members to be very transparent about what they are going to do and how they are going to behave when decisions are made. And I think that that is also true for the Forest Service. And this is something that I think the Forest Service could do a better job of. I think for a lot of collaborative groups, when we work with the Forest Service to develop a project, we assume that that means the Forest Service is going to implement that project. But oftentimes through the objection process, the Forest Service may decide to drop aspects of the project that the collaborative really wanted to see happen. And we may not find out about that as a collaborative group until years later. And so the Forest Service also has an obligation to be very transparent and clear and to circle back with their collaborative partners as well. So it's a thing that applies both ways.
So that was our last question in the chat box. I'll give it another minute. We have a couple minutes left remaining in the webinar for anyone to ask any final questions. If there are no more questions, that's okay. If others pop up, feel free to email me and we can find you your answers that you need.
Yeah, I'm definitely happy to take questions offline or later. So I'm pretty sure that you have my email address, and I'm happy to take email questions or phone. I know that some of this information can be really dense and technical, and not everybody's an attorney like me. And so I'm happy to help walk you through some of this stuff if you have further questions or anything like that.
All right, well, thank you everyone for joining us today. Thank you, Susan Jane, for this discussion and this presentation. We really appreciate it. Thank you to our sponsors for the PNW workshop, Hampton Lumber, Oregon Department of Forestry, the Forest Service, Beneficial State Bank, and Timberline Lodge. Again, this webinar is part of the Pacific Northwest Forest Collaboratives Workshop. Normally it's our 2-day Hood River workshop. This year we're going virtual with a series of webinars from May through October. So stay tuned for about 2 webinars per month coming up. Again, if you have any questions, feel free to email me. My contact information is at the bottom of the PowerPoint here. And if you have any questions for Susan Jane, feel free. She has shared her contact information as well, and we're happy to answer any more questions. So thank you, everyone. I hope you have a great rest of your day. This webinar has been recorded and will be posted to our website along with NEPA 101, which SJ kicked off our webinar series with in May. So thank you, everyone.
Great. Thanks, everyone.